Hello guys, welcome to MEDVERSE and welcome to this new session on forensic medicine. And we'll start forensic medicine and go fast. It will be a revision session, right? We can have 2-3 sessions. Let's see, depending upon the duration. So I'm starting off with introduction to forensic medicine, and here we'll discuss about basics of forensic medicine, definitions, law, ethics, and negligence, right? So introduction. Forensic medicine is the application of principles and knowledge of medical sciences to legal purposes and legal proceedings to aid in the administration of justice. This is the definition of K.N. Reddy. Okay. So pay attention to this definition. Application of principles and knowledge of medical sciences. Okay, we are applying medical knowledge. Okay, to legal purposes and legal proceedings. Okay, we are applying the knowledge to legal proceedings or through law to aid in the administration of justice. So main aim is the administration of justice. For that we are applying our principles and knowledge, right? Also known as state medicine or legal medicine. So we are discussing about medical aspects of law. Likewise, we have something called as medical jurisprudence. Medical jurisprudence is legal aspects of medicine. So it is vice versa, right? So medical aspects of law is forensic medicine. Medical jurisprudence is basically legal aspect of medicine or the legal responsibilities of the physician. A physician has some legal responsibilities, like he has to attend to the summons of the court. He has to he has to be present as an expert witness, right? So juris means law and prudence means prudential knowledge. Why is the doctor summoned to the court? Why is the doctor called to the court? As an ordinary witness. Let's say the doctor has seen someone committing a crime, right? So he can be summoned as an ordinary witness. As a medical practitioner who treated the patient, okay, the patient came for first aid, the doctor provided first aid, and he can be summoned for the medical purpose, right? He can't refuse this once, but he can refuse this expert witness one. Okay, he can be expert witness, that is an expert to give his opinion in a case. Okay, they will ask you if this weapon can produce this type of wound or not. So the doctor can refuse it. The doctor can use his medical knowledge to answer this question. Okay, this is an expert witness. He can refuse, and for being an expert witness, he is also paid. By the court, and this amount is decided by the judge. Okay. Note: the doctor really testifies neither for nor against the prosecution or the defense. Okay. He can't say that the prosecution is wrong, the defense is true, like that. He can't do something like that. The doctor will only exercise his medical rights. He will exercise his medical knowledge, will tell whether or not. Okay. Presumption is not proof and conjecture is not evidence. This is an important line from K.N. Reddy. Okay. Medical evidence is not a substantive evidence. It is a corroborative evidence. Okay. Medical evidence, what the doctor says cannot be taken as completely true. Independent, or you are taking decision on the basis of medical you can say evidence only. This is not true. It can be used as a supporting evidence or a helping evidence. Okay, the medical evidence can only help. Okay, it cannot be like that you are taking decisions on the basis of that medical evidence only. Attributes required in a physician are caution, foresight, and wisdom. Okay, the caution, foresight must be there, and wisdom must be there. Medical ethics is a set of moral principles, okay, which guides the member in doctor patient and doctor state relationship. Okay, so doctor can have a relationship with his patients, with fellow doctors, and with the state. Okay, and he has to follow some set of principles which is called as medical ethics, which are self-imposed and compulsory. So history: first medical legal autopsy was done in Bologna, Italy. Bologna is in Italy. First medical autopsy was done there by Bartolomeo di Vergana. Okay. First book on forensic medicine was published in 1602, that is Fortunato Fedeli. Okay. Fortunato Fedeli was the first book on forensic medicine, F for F. Okay. Paulus Jacquias is known as father of legal medicine or father of forensic medicine. They ask you who is the father of forensic medicine. Paulus Jacquias wrote the book Questiones Medico Legalis. Okay, Paulus Jacquias. Orfila is known as the father of modern toxicology. Other modern toxicology is orfila. Medical etiquette. What is medical etiquette? Conventional laws of courtesy in dealing with colleagues. Like some doctor is there and his clinic, another doctor comes to his clinic, and the doctor is not taking fees because he is his colleague, right? So this is basically not medical ethics, this is medical etiquette. These are some etiquettes. So this etiquettes every doctor must have in order to have a jovial relationship with his or her colleagues, right? What is cause of death? What is mode of death? Cause of death is basically any injury or disease resulting in death. Okay, this is any disease resulting in death. Mode of death is basically system that initiates the process of death. Okay, so mode is basically the system and cause is basically the cause, the disease. Okay, so system means asphyxia, syncope or coma, right? So let's come to Bychart's tripod of life. We'll also discuss in thanatology, but here there is given in NREADY, so I'm discussing tripod of life. So three organs are most important: heart, brain and the lungs. Heart is for circulation. If circulation is absent, if circulation is impaired, patient can land in syncope. Okay, brain, if function is absent, then person can land in coma. Okay, and lungs, respiration, if it is impaired, then asphyxia. So syncope, coma and asphyxia, these are the modes of death. Syncope, coma and asphyxia, these are the modes of death. Okay, if any function stops, the person dies. This is known as atria mortis, which is the gateway of death. Okay, so the person is in the process of dying. This process is basically called the atria mortis. Atria mortis, mortis means death. So gateway of death, right? Manner of death. What is manner of death? Manner may be natural, homicidal, accidental, suicidal, or it may be undetermined by any medical procedures, right? It can be natural death, it can be homicidal death, it can be accidental death, it can be suicidal, undetermined death. Person in Kota hanged himself. Okay, what is the cause of death? Cause of death is basically hanging. Why the person died? Okay, this is the immediate cause why the person died is basically the cause of death. Mode of death is basically why the person died. Okay, due to hanging there occurred asphyxia. So asphyxia is the mode of death. You cannot write asphyxia as the cause of death. Many physicians do this. Okay, and manner of death is basically suicidal. Okay, because he hanged himself due to suicide. Okay, so don't confuse these three terms. July 1, 2024, new criminal laws replaced IPC, CRPC and Evidence Act. Okay, you must be knowing that IPC is replaced, CRPC is replaced, Evidence Act is replaced. Indian Penal Code is now known as IPC, is now changed to BNS, that is Bharatiya Nyaya Samhita. Describes offenses and punishments. 358 sections are there. 358 sections are now there in BNS. Criminal Procedure Code, that is the CRPC, is now replaced with BNSS, that is Bharatiya Nagrik Suraksha Samhita. Bharatiya Nagrik Suraksha Samhita. Okay, so procedures in crime basically. CRPC is a set of procedures which they follow in dealing with criminals, right? So it's the procedure in crime, and 531 sections are there. And Indian Evidence Act IEA is now replaced with BSA. Indian Evidence Act is BSA, Bharatiya Saksha Adhiniyam. Okay, Bharatiya Saksha Adhiniyam. Okay, so Saksha is basically witness in Hindi. 170 sections are there in IEA related to admissibility of evidence and recording of evidence. Okay, basically the rules of recording of evidence. So BNS, which was the erstwhile IPC, and CRPC, which is now replaced with Bharatiya Nagrik Suraksha Samhita, that is BNSS, and Indian Evidence Act is now replaced by Bharatiya Saksha Samhita, that is BSA. Okay, and the date which they replied is 2024. So books you must be following, and some books are not updated based on that. Offenses. What are offenses? Offenses may be two types: cognizable and non-cognizable. Offenses are something which is not, you can say, permitted by public point of view. Okay, and the majority of people won't permit something, that becomes an offense. So cognizable offense, non-cognizable offense. Police can raid without warrant, okay, from magistrate. Okay, so whenever police comes to a spot of crime, they have a warrant. They show you a warrant and tell that you are under arrest, right? You must have seen that. But if they are doing without a warrant, if they don't require a warrant, directly they can go and arrest you. Okay, this is called a cognizable offense under 2G BNSS, like MDRD, murder, dowry, death, rape and dacoity. Okay, murder, dowry, death, rape and dacoity. Okay, see, this is a cognizable offense. These are the cognizable offense. These are serious offenses and they don't require any warrant. Non-cognizable, police cannot arrest with a warrant. Okay, like 2 OBNSS cannot arrest without a warrant. Okay, they require a warrant from the magistrate. And then can only arrest you. Rest of the offenses except murder, dowry, rape and this dacoit, they can come and arrest without a warrant. Then offenses based on punishment. So we can have a summons case and a warrants case. Okay, summons case and a warrant case. So offenses based on arrest is basically cognizable, non-cognizable. Offenses based on punishment can be a summons case or a warrant case. Summons case is cases in which punishment is imprisonment less than 2 years. Okay, this is a summons case. Warrant case means punishment is imprisonment more than 2 years. Can be life imprisonment or it can be death sentence. Murder, attempt to murder, dowry, death, all of this. Now types of offenses based on compromise. It is compoundable offense and non-compoundable offense. Compoundable offense is a minor offense in which victim can compromise with the accused and drop the case. Okay, let's say they decided that it is a minor case. The victim is basically approaching, he's saying sorry to the accused is saying sorry to the victim is also telling okay, I won't complain, and case is now dropped. Okay, this is compoundable offense. They compromised it, right? So understood, compoundable offense, non-compoundable offense. So compoundable is basically minor offense which the victim can compromise with the accused and drop the case. Okay, and non-compoundable offense is serious offense in which the victim cannot compromise with the accused. It is not permitted and cannot drop the case, right? So civil case and criminal case. Civil case, here we have a plaintiff which files the case in a civil court. Defendant who has to defend himself. One who goes to the court and files the case is known as plaintiff. One against whom the case is being filed and who has to defend it is called a defendant. So there is a dispute between parties here. The burden of proof. Okay, plaintiff has filed the case, so he has to prove why the person B is basically alleged to commit the crime. Okay, so burden of proof lies upon the plaintiff. Burden of proof lies with the plaintiff. He has to prove the case with appropriate evidence. Okay, so plaintiff have to provide some evidence and he has to, you can say, prove the case against the defendant. And verdict, what is the verdict? Verdict is basically judge's decision. He can tell the defendant if he is guilty. If the defendant is guilty, he can tell the defendant to give some compensation to the plaintiff, or any direction compensation. Okay, now come clinical case. Understood civil case. Clinical case, what is the structure of a criminal case? So we have a assailant here. Assailant, let's say the person assailant is a gun. He shot the gun and the victim is injured or the victim died, anything. So this is always against a state versus the accused. It is not a criminal case. Very important point I'm telling. Criminal case is not against the assailant. This is not assailant versus victim. It is not like that. It is state versus assailant. Because the victim is said to be a part of state. So state will fight for you. It's not that the victim only can can have a case with the assailant, or victim versus assailant. It's not like that. It is state versus assailant or state versus accused. Since Why it is state? Since offense against any person is seen against offense against people of that state. Okay, so if a person is being killed or murdered, the government sees it's like that it is a crime against humanity, it is a crime against humanity, or it's a crime against the state. Okay, so state will fight for you. State versus accused, state will fight for you. So government of the state will file the case against the assailant and it will fight for you. So state here is the prosecution, accused here is the defense. State here is the prosecution, accused here is the defense. Okay, so state will appoint a public prosecutor, and the burden of proof lies upon the public prosecutor. Okay, so burden of proof lies always on the prosecutor side, and accused is the defense. Accused will appoint a defense lawyer. He has to prove beyond doubt. And the verdict, what is the verdict? Verdict means judge's decision. Judge can give a direction to pay some fine or can imprison the accused, right? This is done. Now let's come to magistrates. What are the magistrates? Administrative magistrate, judicial magistrate. There are two types of magistrates, administrative and judicial. Administrative magistrates, the district magistrate, okay, additional district magistrate, ADM, okay, SDM is subdivisional magistrate, executive magistrate, all administrative. Judicial magistrates are those who sit in courts. Okay, so depending upon the crime, the magistrate will conduct the inquest. Okay, inquest is basically, what is inquest? Inquest is basically an inquiry, not injury, inquiry into the cause of death. Okay, the cause of death or crime. It is an inquiry. So who will conduct inquiry? You must have seen the judges sit in courts. So that is a judicial magistrate who sit in courts. But we have something called administrative magistrates like Tehsildar, deputy collector, Tehsildar, all of this. Okay, like district magistrates or subdivisional magistrate, executive magistrate can conduct inquest in case of dowry death and exhumation. Okay, in case of dowry deaths and exhumation, they can conduct inquest. In case of custodial deaths means in police custody, in jails, death in juvenile homes. Okay, all of these are custodial deaths. So who conduct deaths, inquest in custodial deaths? The judicial magistrate. And who conduct inquest in case of dowry death or exhumation? Administrative magistrate. What are the administrative magistrates? DM, ADM, SDM, executive magistrate. Okay, so these are the things which are important in the introductory part. Let's move on to the next part. So let's start with legal procedures. What are the legal procedures which are important? Let's see it. Legal procedures. Some commonly used terms. IPC, I told you, is replaced by BNS. Criminal Procedure Code is a mechanism of punishment against criminal law. I told you is replaced by BNSS. And Indian Evidence Act is replaced by BSA. Okay, deals with the law of evidence, right? Okay, then criminal law deals with offense and public interest. First party accused represented by public prosecutor. I told you all this. Civil case, I told you plaintiff and defendant are there. Inquest. Now comes inquest. Inquest in literal meaning is to seek or to know something. Inquiry into the cause of death is the definition of inquest. Inquiry into the cause of death. Inquest can be two types: police inquest and magistrate inquest. Police inquest is the most common form of inquest followed in India. Okay, police inquest. Basically, this is done by, this is given under 194 BNSS. Okay, 194 BNSS gives police inquest. 196 BNSS gives the magistrate inquest. Okay, magistrate's inquest. Police inquest is basically usually done by sub-inspector, not below the rank of head constable. Okay, so minimum person who can conduct a police inquest is a head constable, right? Okay, so IO is basically investigating officer or inquest officer, and this must be above the rank of head constable or a head constable, HC head constable or above that can conduct this police inquest. And how he conducts this? With the help of two respected person who saw the crime, okay, who are called as panchas. Two respectful person of that village prepares a report of death, and inquest report, which is called as Panchanama, is signed by the IO and the Panchas. Panchas are two respectable person, I told you. So we have three signatures here, one of the IO and one of the two Panchas, right? Panchanama is forwarded to the magistrate and body is post-mortem, sent for post-mortem without removing clothes, with a requisition letter which is called dead body challan and a copy of inquest, right? So basically police comes, who is a head constable or above that rank, and he asked two person who will act as Panchas. They all three will sign and prepare the report of death. The report of death is prepared and inquest report is prepared. Inquest report is basically known as Panchanama. Panchanama is signed by IO and the Panchas. It is forwarded to the magistrate, and dead body is sent for the post-mortem without removing the clothes, with a requisition letter and a inquest letter or requisition letter, the copy of inquest and a requisition letter, dead body challan, okay. And post-mortem examination is a part of the inquest, okay. This is called as your police inquest. And we have something called magistrate's inquest, which is a superior one but not usually followed. Usually we follow police inquest. This is done by district magistrate, collector, deputy commissioner, sub-divisional magistrate, RDO, tehsildar, executive magistrate, okay. So basically this is done by administrative you can say magistrates, right? So judicial magistrate is conducting this police inquest. Police is conducting, but he is forwarding the Panchanama and the with the signs to the judicial magistrate. But here in magistrate's inquest, it is done by district magistrate, like collector, okay, subdivisional, deputy commissioner, SDO, okay, and RDO, tehsildar, executive magistrate, empowered by government. Which cases it is done? You can remember by this mnemonic DICE, DICE. So ICE, I and C is conducted by judicial magistrate, and D and E are conducted by executive magistrate, okay. Executive magistrate means all of this, tehsildar, etc. And judicial magistrates are who sit in courts. So DICE, D is for dowry death, I is for in case of death of a woman within 7 years of marriage, okay, within 7 years, less than 7 years if there is a death, I. C is custodial death or disappearance, and E is exhumation. So dowry death and exhumation, I told you earlier also, it is conducted by the executive magistrate, okay. And I and C is basically within 7 days of marriage, and custodial death is basically conducted by judicial magistrate, okay. And what are the other forms of inquest? We have coroner's inquest, which was introduced in 1902 in India but was abolished in 1999. So 1902 to 1999 we had something called coroner's inquest. Now it is done in US, UK, Canada, okay, US, UK and Canada. Basically coroner is a person who is appointed by the government who is empowered to conduct the inquest into the manner and cause of death, okay. He can be an advocate, he can be an attorney, he can be a first class magistrate, okay. So basically this is a coroner's inquest, okay. A coroner is there, and coroner is a government or judicial officer who is empowered, who is given power. And coroner cannot impose fine, and accused need not be present during the trial. The coroner can take decision anonymously. This is not that good system, so it is abolished in India in 1999. And the second system is basically medical examiner system, not in India, but is the best system available, best, done in Japan, Canada, USA. Medical practitioner performs the function of the coroner, okay. So the doctor is performing the function of the coroner. It doesn't have any judicial powers, but this jury is there, some jurors are there in jury, okay. And this medical examiner system is basically medical exam practitioner is performing the functions of the coroner. And another system is procurator fiscal system, okay. Procurator fiscal system is not followed in India, it is practiced in Scotland, okay. And IO can summon the witness for inquiry, 195 BNSS, this is there, okay. And now civil case and criminal case, I told you about civil court, criminal court. And inquest has 4 components, and inquest report, I told you, right? Inquest report, it has 4 components: identity of the person, place of crime, time of crime, and cause of death, okay. So inquest report, it has 4 components, basically remember this. So we are done with basic terminologies. Now I'll move to the another part. Okay, let's read about the courts of law. What are the courts of law? Right, so we have a civil court and a criminal court. Criminal court can be divided into 4. Supreme Court, High Court, Sessions Court, and Magistrates Court. So Supreme Court is the apex court of the country. It's the highest judicial tribunal. Power of supervision over all courts. Okay, it has a supervisory power over all courts. It is a appellate courts in all criminal cases. Appellate courts means a court that is empowered to hear an appeal of a trial court or a lower tribunal. Means you took a case to the High Court and you are not satisfied with the decision. You can appeal to the Supreme Court to hear your decision. So it is empowered to hear an appeal of the trial court or the lower tribunal. Okay, any court lower than Supreme Court, you can go to the Supreme Court, you can approach the Supreme Court. It is in New Delhi. Okay, it has the power of supervision over all courts. It is the highest judicial tribunal, and Article 354 law declared by Supreme Court is binding on all courts. Okay, Supreme Court is the main decision making power. It has the main decision making power. High Court. High Court is the apex court in a state, usually in the capital of the state. Okay, and judges are appointed by the President of India. It may try an offence and pass any sentence authorized by law. All apical courts can. It may try any offence and pass any sentence authorized by law. Appellate court in criminal cases, it is also an appellate court. It can hear the you can say decision from its lower tribunals. Okay, like a case you are not satisfied with the decision of the Sessions Court, you can appeal to the High Court. You are not happy with the decision of High Court, you can appeal to the Supreme Court, right? Except High Court and Supreme Court, all are courts of trial. Sessions Court, Magistrates Court, all are courts of trial except High Court and Supreme Court. Sessions Court is the apex court of a district. Okay, every district has a Sessions Court established by the state government. It can pass any sentence authorized by law, but that sentence of death must be confirmed by High Court. A Sessions Court cannot pass a death sentence. Okay, it can pass any sentence except death. It can pass death sentence in one case. That is, if this death sentence is being verified by High Court. Okay, if the Sessions Court will send a report to the High Court that we are passing this death sentence, if the High Court allows it, then it can only pass the death sentence. Also known as initiating court. All IPCs are triable and Sessions Court also. Okay, what are the powers of judges? We will see. Okay, Class 2 Judicial Magistrate. Then we have Class 1 Judicial Magistrate, or the Metropolitan Magistrate, then we have the Chief Judicial Magistrate, that is the CJM. Then we have the Assistant Session Judge, okay, ASJ, Assistant Session Judge, then Additional Session Judge, okay, Additional Sessions Judge and Sessions Judge. Okay, so class 2 is basically can imprison a person up to 1 year. Okay, and can you can say apply fine up to 10,000. Okay, 1 year 10,000. Class 1 Judicial Magistrate basically up to 3 years and 50,000. Okay, 3 years and 50,000. Chief Judicial Magistrate can imprison a person up to 7 years. Assistant Session Judge up to 10 years. Additional Session Judge, all punishment. Okay, so additional and Sessions Judge can give all punishment, can give you can say advice for unlimited fine. But this Assistant Session Judge is a 10 years you can say imprisonment and unlimited fine, and Chief Judicial Magistrate 7 years and unlimited fine. Okay, class 1 basically up to 3 years and 50,000, class 2 1 year and 10,000. Understood? Juvenile Court is under Juvenile Justice Act, known as Juvenile Justice Board, JJB. Okay, Juvenile Court or Juvenile Justice Board. It has 3 board members. One is the Principal Magistrate, which is of class 1 Judicial Magistrate rank. Class 1 we talked over here, right? Up to 3 years imprisonment and 50,000 fine. His powers consist of 3 board members. Principal Magistrate, which is a class 1 Judicial Magistrate. Social Worker 1, Social Worker 2, and one of them must be female. So 3 board members: Principal Magistrate, Social Worker 1, Social Worker 2, and one social worker has to be a female. known as Juvenile Justice Board, and it is established under Juvenile Justice Act. And here under 18 years people can be tried, right? Death sentence. Death sentence in India, judicial execution in India happens only by hanging. Hanging is the only method of judicial execution in India. In other countries we have something called electrocution. There electrocution may be there, right? Lowest court that can give the death sentence is a sessions court. A sessions court is the lowest court that can give a death sentence. Okay, and sessions court forwarded to High Court, I told you, can be forwarded to Supreme Court. If the High Court can confirm the sentence, commute or cancel. Okay, High Court has three fates. The death sentence which is forwarded by the Sessions Court to the High Court can be confirmed. Okay, they can confirm it, they can commute it. Commute it means death sentence can be changed to life imprisonment, or death sentence can be changed to 10-year imprisonment, anything. Or they can cancel the sentence totally. Okay, and if it is done, if you're not happy, then you can go to Supreme Court. If Supreme Court confirms death sentence, okay, if Supreme Court is giving death sentence, only one person can save you, and that is the President of India. Okay, so if Supreme Court is giving the death sentence, you will appeal, you will have a mercy petition, to the President of India, the President of India, and the President can commute or pardon the death sentence. Okay, or the state governor can file a mercy petition, and according to, as per Article 72, the President can commute or pardon the death sentence. Okay, if a pregnant female is given death sentence, High Court can commute the death sentence into life imprisonment. Okay, then these are the offenses: heinous, serious, and petty offense. Okay, this is not much important in PS, this FMT point of view. Heinous offense is more than 7 years death sentence, not death sentence, imprisonment. This is basically more than 7 years. Serious is 3 to 7 years. Petty is less than 3 years imprisonment. Okay, petty offense less than 3 years. Serious offense 3 to 7 years. Heinous offense more than 7 years imprisonment. Okay, so that we come to the end of the courts of law. Let's move on to the next part. Let's come to the Indian legal system. What is the Indian legal system is about? Evidence. What is evidence? Evidence is any statement or document to prove or disprove a fact or truth. Okay, so evidence is basically a statement or a document to prove or disprove a fact or truth. Okay, so we can prove a fact or a truth, or can disprove a truth. Okay, so evidence is basically a statement. We can have some types of evidence like oral evidence, documentary evidence, and circumstantial evidence. Okay, so three types of evidence: oral, documentary, and circumstantial. Oral evidence, witness present in court and it being written about what he or she is saying. Okay, so oral evidence is basically you called a witness and the witness is telling. It can have three types: direct, indirect, and hearsay. Okay, so oral evidence can be of three types. One is a direct evidence. That's the best one is that witness has seen the crime. Okay, so what's good, what is better than that? Indirect means that witness is saying something. Witness is saying that the person went with the knife but haven't seen the person. Okay, witness have seen a person carrying a knife. Okay, and the witness seen a dead body. He saw a person carrying a knife, he saw a dead body. It implies that the person killed it, but haven't seen the person stabbing the dead body or the person stabbing the victim. Okay, direct evidence, just let me give you an example. Let's say here's a person. This is the criminal. He has a gun. And this is the victim. The criminal killed the victim. And while he killed the victim, the witness was present. So this witness is a oral witness. He is telling that I was present and the criminal killed the victim before my eyes. This is a direct evidence. Okay. Next situation is that this criminal went inside a room. where the victim was present. Okay, the criminal killed the victim inside the room. The witness is outside the room. He saw the criminal going with the knife, going with the gun. He saw the victim dead. He didn't see that he didn't see the assailant directly killing the victim. This is indirect. Now, another thing is that this is a criminal, this is the victim who died, this is a witness. He heard from people that a person was killed with the gun, okay, and he is dead. So witness has heard the people. The witness has heard the people, and now he is telling it in court that I heard that the person was being killed by a gun. So this is hearsay. Okay, witness has heard what others were saying about the crime. And hearsay evidence is not valid in India. It's the most inferior type of thing, because what you see is basically what you can tell with confidence. What others are saying, you can tell that with confidence. Okay, so Indian government doesn't recognize hearsay evidence. Okay, now documentary evidence is basically like dying declaration. Okay, dying declaration, the person is dying and he or she has written something that you can say I donate all the property to in my name, in my son's name. Okay, like that, dying declaration. Or the person is saying that this person is responsible for my apparent death. Okay, something, a person is dying and is doing a declaration, saying something, or this thing is known as dying declaration or documentary evidence. Ideally should be taken by administrative magistrate. Mental fitness has to be certified first by the doctor. Okay, because a dying person may have a altered sensorium. Okay, so he must be in mental fitness, must be ascertained first. Okay, person in dying declaration, first mental fitness has to be ascertained. That is called as compos mentis. Before recording the dying declaration, if doctor has to certify the mental fitness, known as compos mentis, and leading questions cannot be asked over here. The person is allowed to tell. Leading questions cannot be asked. In the absence of magistrate, dying declaration can be recorded by the doctor in presence of two witnesses. Okay, so administrative magistrate is the ideal person, but in absence of this magistrate, the dying declaration can be recorded by the doctor with two other witnesses. Okay, circumstantial evidence, personal identity at crime site, proving based on circumstances. Okay, so simple witness and expert witness. So circumstantial understood, personal identity at crime site, and this is proved based on circumstance. What circumstances led to the crime? So we don't need to know much about the circumstantial evidence. This much is sufficient. Witnesses can be simple witness and expert witness. Simple witness cannot give his or her opinion on the cause of death. Okay, simple witness can only tell what he or she saw. Okay, he cannot give an opinion that this person is responsible for this crime and this weapon is responsible for this alleged crime. No, the person can only say that yes, I heard this person screaming, yes, I heard this person saw this person dead, yes, I heard the person was being killed. Okay, like that. It cannot give opinion on the cause of death. Cause of death cannot be given by simple witness. Expert witness is one who is expert in his field of work. Okay, he is expert in his field of work, and he can give opinion on the cause of death, like autopsy surgeon, like a fingerprint expert, like a calligraphy expert. Okay, anything. So A stabs B 3 times and this caused death. X sees this and Dr. Y does the autopsy. So X, who saw this, is a simple witness. Dr. Y, who did the autopsy to find the cause of death, can only be an expert witness, has the power to give opinion of the cause of death based on his observation. What is subpoena or summons? Document issued by the court bearing its seal in duplicate, ordering a person to appear in a particular date or time. Okay, so this is a document and this is sent to a person, and this is sent by the court to the person, and the person has to be present in the court in that particular date and time. So document issued by the court bearing its seal in duplicate, ordering a person to appear in a particular date or time. Subpoena duces tecum and subpoena testificandum. Two types are there. Subpoena duces tecum. Subpoena duces tecum to bring documents for use in hearing. So documentary evidence. The person is asked to bring documentary evidence. And subpoena testificandum. Subpoena testificandum. Okay. To testify, to appear and give oral evidence only. Okay. Subpoena duces tecum is basically a documentary evidence. D for documentary evidence. Okay. Subpoena duces tecum documentary evidence, and subpoena testificandum to appear to give oral evidence. Okay. Now let's suppose you are the doctor and you receive 2 summons in the same day. Okay. You receive 2 summons on the same day. What will give you? Who will you give priority to? Which summon you will prioritize? So first thing is that higher court must be prioritized over lower court. If you received a summon from the high court and sessions court, which will prioritize? High court. Criminal matter is prioritized over civil matter. Okay, let's say 2 same courts, 2 session courts have provided to summons. Okay, session court 1 and session court 2. Here you have a criminal case, here you have a civil case. We will first go to the criminal matter. Again, if the courts are of same level, if the matter is of same level, then appear from where someone was received first. Okay, let's say a court you received someone at 6 a.m. and another court you received someone at 7 a.m. Okay, you will go to the court where someone was received first. Okay, and disobedience of someone, okay, it is punishable. This is CRPC is now obsolete, right? Okay. Types of court cases, civil and criminal. Okay, this again repeated, nothing to be worried of. We discussed all this, right? Defense lawyer, defense is to hire. Okay, this is important. Order of trial, how a trial is being conducted from witness, right? Evidence recording from a witness. Let's say you are a witness and they want evidence from you. You are a simple witness, let's say. So how will they record the evidence? Okay, what is the procedure? So we have 3 methods, which is called examination in chief, direct examination, then cross examination, then lacuna after cross examination. Okay, direct examination, cross examination, and lacuna after cross examination. Direct examination, who will do the direct examination? Conducted by the lawyer of the same side. Okay, let's see what the prosecution witness. Prosecution lawyer will do the direct examination. You are the defense witness. Defense lawyer will do the chief examination. And here only leading questions are not permitted. Leading questions are not permitted. Leading questions mean yes no questions. Yes no questions are not permitted. Here you have to ask open-ended question. Open-ended question mean what you saw, like that, what you saw. He can't ask that is this person the criminal, yes or no. He can't ask that. Leading questions are not permitted. Only open-ended questions are permitted. Open-ended questions are permitted in examination in chief or direct examination. And this direct examination is done by the lawyer of the same side. Okay. Then cross examination. What is cross examination? Cross examination is done by lawyer of the opposite side. Okay, the opposite side lawyer will do the cross examination, and here leading questions are permitted. He can ask you yes or no questions. The lawyer of the opposite side. Let's say the prosecution witness, then the defense lawyer can ask you the question. And he can ask yes no question, leading questions only, and witness is bound to answer in yes or no. This is cross examination. Then lacuna after cross examination, volunteering of statement by the witness. Okay, so after the cross examination, the witness can give any additional statements. Okay, and then we do redirect examination or re-examination. Here there is no leading questions by same side lawyer. Again open-ended question. And then 5th one is the questions by the judge. Okay, the judge can ask questions at the end. Judge can stop the witness at any point of time in the examination total, in the cross, in the chief, any point of time. Judge can ask you questions. Okay, So basically, what is the sequence here? First is the examination in chief. Examination in chief is conducted by same side lawyer, and same side lawyer will ask you open-ended questions, and you have to describe the matter. You can't ask yes or no, right? Then we do cross examination. Cross examination is done by opposite side lawyer. Opposite side lawyer will ask you leading questions. Leading question you have to answer in yes or no. Then we do lacuna. After examination, lacuna, you will do volunteer the statements. If you want to say something, you can volunteer. Then you will be directed to re-examination or redirect examination or re-examination. This is again done by same side lawyer, and he can again ask you open-ended questions. Okay, no leading questions. And then you'll be asked questions by the judge. And questions by judge is basically can be at any stage, but we write at end. Okay, you can ask you questions at any stage possible. All these rules are given by 142 BSA. Okay, Indian Evidence Act was erstwhile, and now it is BSA, 142 BSA. Judge can ask question at any time of proceeding to clarify, and can recall any witness. Okay, re-examine any witness. Any question can ask. The judge can ask leading, the judge can ask open-ended, any type of question can ask. What is perjury? Perjury is basically lying during witnessing under oath. Okay, you take an oath, right? Using a holy book, ask they keep you Gita or something, or Quran or something, they ask you to take oath. Okay, 227 BNS. Under 227 BNS, if you are lying during witnessing under oath, you are a witness and you are telling lies after taking oath, then it is punishable. Okay, under 229 BNS, it will punish you. Okay, and fabrication of evidence, if you fabricate any evidence, you made a story of your own, then 228 BNS it will be punished. Who is a hostile witness? Hostile witness is one who hides a vital part of statement during initial statement recording. So perjury is basically fabricated witness. Okay, fabricated things or lies. And hostile witness is basically someone, hostile witness or unfavorable witness or adverse party. Okay, hostile witness or unfavorable witness or adverse party is one who hides or changes a statement. Okay, it can manipulate a vital part of his statement, or you can hide some statement during initial statement recording. Leading question can be asked by self lawyer or if witness turns hostile. Okay, so self lawyer also, the same side lawyer can also ask leading questions if the witness turns hostile during direct examination. So direct examination in chief, same side lawyer and leading questions are not permitted, but another exception is that if the person is hostile, if the person has become hostile, then he can ask you leading questions. Okay, then leading questions can be asked normally during cross examination by defense lawyer or hostile witness, direct examination by prosecution lawyer. Chief examination, cross examination. Okay, this is done. Redirect examination to clear any doubt during cross examination. No new facts are brought. Summons and warrants case, I told you, summons case were less than 2 years, warrant case more than 2 years. And summons case, judge directly reads the charges to the accused, and warrant case, judge holds a pre-trial discussion to frame the charges himself, right? So basically in summons case, the judge is directly giving you the charges. Okay, less than 2 years means not that serious crime. And warrants case more than 2 years, life imprisonment or death where it is involved, then the judge will hold a pre-trial discussion. Before the trial there will be discussion to frame the charges. Okay, what is oath? Oath is the first step before giving any evidence. So we take oath like, I do swear in the name of God that I am talking truth, whole truth and nothing but the truth. A person is an atheist, non-believer in God, then he will say, I do solemnly affirm that I am talking truth. Okay, the person is an atheist. Oath is compulsory. If oath is not taken, if there is a refusal to take oath, it is punishable under 213 BNS. So 213 BNS is the punishment for not taking oath. What was 227 BNS? Look at this answer. Here we discussed perjury. Perjury is 227 BNS. Okay, fabrication is 228 BNS. Punishment for fabrication and perjury is 229 BNS. 142 BSA. 142 BSA was this examination procedure, evidence recording. 142 BSA. Okay, and the judge question 168 BSA. So oath is compulsory, and what's the exception? A child less than 12 years need not take oath. A child less than 12 years need not take oath. This is important. Dying declaration. What is dying declaration? Document made on statement given by a dying person about his cause of death leading to death. Okay, so this is a statement given by a dying person. I told you, oral, written, on gesture. If the victim is very much on the verge of dying, he can have a gesture based dying declaration also. It is documentary evidence given by 26(1) BSA. Ideally by magistrate. I told you, administrative magistrate, and if magistrate is not available, then doctor in place of 2 witnesses, or police can also take, or any person in place of 2 witnesses, he can take a dying declaration. Okay, when all of these are not available. So magistrate is first preferred, then doctor, then police, and then any. When it is valid, when the person has sound mind. Compos mentis must be certified by the doctor beforehand. No force or influence must be there, determined by court of law. Cause of death should be the question, and the person must die. If the person is in the verge of dying but didn't die, if the person is on the verge of dying but didn't die, then the dying declaration is not valid. Procedure. No oath. Okay, because we assume that the dying person always tells the truth. Okay, our belief is that thing, that a dying person always tells the truth. No alteration of words, prompting or leading questions. No leading questions, no alteration, no prompting. Okay, and no disturbance must be there. The person must be, you can say, must be allowed to speak on free will, right? Verbatim, recorded as it is. You cannot change the language. If the person is telling this in Hindi, you have to write it in Hindi. It must be in same language. You can't change words in that. Okay, it must have a signed thumb impression also. Okay, it must have a thumb impression also, and must be forwarded to the magistrate as soon as possible. If the patient survives after giving dying declaration, it is rendered invalid, but it can be used as a helping evidence. Okay, if a person survives after giving dying declaration, it is invalid but can be used as a helping evidence. What is dying deposition? Dying deposition. Dying declaration is another one thing, and dying deposition is one thing. Bedside quote. Dying deposition means bedside quote. Recorded by magistrate or judge only. Dying declaration can be recorded by any person. Like you can say that it is given priority. The administrative magistrate is given priority, then doctor, then police, then any other person. But dying deposition, other person can do. It is recognized. It is recorded by the magistrate or judge only. Here we take oath. And here we have accused or defense lawyer present. Here we have cross examination. Here we have leading questions. Okay. It is superior than dying declaration, valid even if person survives. Okay, but it is not practiced in India. Okay, so basically a person is dying and you are setting up a court, having a accused or defense lawyer also. A defense lawyer is present. Cross examination, he can do cross examination also. He can ask you leading questions also, right? And a oath is also taken. So all court procedures are followed besides a dying person, and it is only recorded by a magistrate or judge, right? And it is also valid if the person is alive. If the person has not died, it is also valid, right? But it is not practiced in India. What is conduct money or diet money? Conduct money or diet money. So it is paid by the party who called the witness, amount decided by the judge. Okay, so a party who called a witness, this party has to pay the witness, and how much he has to pay will be decided by the judge, and this money is called as the conduct money or the diet money. This is given to the expert witnesses also, right? So conduct money or diet money is the important thing which you have to remember. Okay, now let's move on to the next part. Now let's talk about medical ethics and negligence, right? Medical ethics is in Greek is basically meaning habit, action or character. So set moral principles which guide in dealing with others, other patients and the state. Okay. So it is a set of moral principles in which the doctor is basically interacting with his fellow doctors, with patients and with the state. I told you earlier this. So mnemonic is there, some basic principles are there, A, B, C, D, E. A is basically autonomy. Patient has the right to choose his or her treatment. B is beneficence, promote good. A doctor has to do good and he must do his actions must be in the benefit of the patient. C is confidentiality. The doctor has to keep the identity and the disorder of the patient confidential, right? Then D is do no harm or non-maleficence. Doctor has not to do any harm to the patient, must be working the benefit of the patient. E is equity or justice. Patients have to be treated equally or fairly, irrespective of their caste, creed, duration of treatment, okay, irrespective of their disorder, irrespective of anything, right? Then state medical council. So state medical council has some rules like registration, erasure of names and disciplinary action. So state medical council, every state has a SMC, state medical council. Any doctor who is passing his internship, his or her internship, has to be registered by this. It enrolls new members in the state medical register. The registered medical practitioners are enrolled. Okay. Erasure of name, if a doctor is died, okay, if a doctor died, death of the doctor, if the doctor has become untraceable, if there is a disciplinary action, if the doctor is charged of negligence, then disciplinary action, all of these things is done by the state medical council. And this disciplinary action, the state medical council can have a penal erasure. Penal erasure is basically the lawful erasure of the name from the state medical register. Disciplinary action against the registered medical practitioner. Let's say there's a complaint, convicted or suo motu case. Okay, there's a complaint against the doctor. So president from the subcommittee, president forms a subcommittee, and the subcommittee has doctors of good repute, usually odd numbered doctors to facilitate voting. And even numbered doctors, they can divide and you cannot have a vote, but it features odd number of doctors of good repute, right? A subcommittee can acquit the doctor. Acquit the doctor means they drop the charges. Let's say persons complain that this doctor is responsible for this illness or something, but if this is not true, if they find out that this is not true, they can free the doctor from the charges can be dropped. They can warn the doctor. Okay, if it is a mild to moderate level of negligence, they can give a warning notice. Okay, or they can directly remove the name of the doctor. Okay, it can be temporary or permanent. They can temporarily remove the name for some months or weeks or something, or they can permanently erase it in case of serious professional misconduct. Okay, in case of serious misconduct, they can permanently erase. Like if doctor is doing unlawful, unethical experiments on the person due to which the people died, this is a permanent erasure case. Okay, and this permanent erasure of name is called as professional death sentence. So doctor is given professional death sentence, he can appeal in the ethics and medical registration board. Okay, he can appeal in the EMRB. Okay, he can appeal in the EMRB is a wing of National Medical Commission, NMC. NMC was established in 2020, 25 September, NMC 25 September 2020 establishment. NMC has 4 major councils: undergraduate medical board, postgraduate medical board, medical assessment and rating board, ethics and medical registration board. Okay, so 4 councils are there under NMC. Undergraduate medical board, UMGB, basically they formulate courses for your undergraduates like MBBS curriculum. Okay, NMC curriculum, right? Postgraduate medical board for standards and postgraduate courses. Okay, for postgraduates basically. Then medical assessment and rating board, they basically have give permission to for establishment of medical colleges, and they maintain the minimum standards. Okay, maintain minimum standards, and they supervise over medical colleges. They come for inspections and all, right? So medical assessment and rating board. And ethics and medical registration board. Ethics and medical registration board is basically regulating professional and ethical conduct. Okay, maintaining a ethical conduct of the people. So they can you can say appeal in the EMRB. So if a doctor is given professional death sentence, he can appeal in the EMRB, that is medical ethics and registration board. Ethics and medical registration board. And these four are the basically components which they can appeal. After EMRB appeal, after they appeal in the EMRB, if he or she isn't satisfied, can approach NMC directly. Okay, so NMC schedules are there. Sometimes they ask you first schedule, second schedule, third schedule. 3 schedules, part 1 and part 2. Third has part 1 and part 2. First schedule is the list of degrees awarded by Indian universities. Second is list of degrees awarded by foreign universities. Part 1, list of degrees Indian universities are not included in schedule 1. Schedule 1, first schedule not included. Then part 1, third part 1. Third part 2, medical qualification of foreign university not included in schedule 2. Not included. If it's not included in schedule 2, then third part 2. Third part 1, third part 2. Okay, second, first. Professional misconduct or infamous conduct is unethical act. Okay, and they have many, you can say, subcategories of infamous conduct or professional misconduct. We'll go to the definition later, but now we'll read what are the things, what are the list of professional misconduct, or what constitutes a professional misconduct. So we have A, B, C, D, E, F, G. Okay, so A is basically addiction, alcohol, association with unqualified persons, abortion, they're doing criminal abortions, advertisements and adultery. Then addiction, alcohol, association with unqualified people, abortion without MTP Act, defying MTP Act, advertisements, inappropriate advertisements or disproportionate exaggerated advertisements. You can advertise about 3 times about starting of you can say your clinic. Okay, if you're starting your clinic, if you're then restarting your clinic. Okay, 2 times basically. 2 times you can advertise, and you have to keep a proper board with NMC recognized qualifications, right? You can you can advertise, but you have to do it in a professional way or appropriate way. And if you are disproportionately exaggerating it, if you are claiming mysterious results or surprising results, or results is not feasible, then advertisements you can be charged of professional in misconduct or infamous conduct, right? So addiction, any alcohol addiction, association with unqualified people, abortions like criminal abortions which are defined MTP Act, advertisements which are appropriate, must be appropriate or disproportionately exaggerated, then you can be charged, or adultery, right? B is bribery. C is conviction, commission, covering. Conviction, commission and covering. Covering is basically assisting on one unqualified person. Okay, you are employing someone for conducting a surgery, but he is not qualified enough to conduct a surgery, then covering is there. And if you are covering a person which you know is a fake doctor, but you are saying that the person is a real doctor and covering his crime, then you can be charged. Conviction, commission and covering. B is bribery. D is dichotomy. Dichotomy is fee splitting or disclosure of professional secrets. Okay, you can be charged of disclosure of professional secrets. Dichotomy, fee splitting means you are having a lab tied up with you. Okay, lab is tied up with you, and the lab is telling that you will get 5,000 for each ultrasound you refer. Okay, so you are referring to that particular lab only for your monetary benefits. This is dichotomy. E is endorsement of any medical company or brand. Okay, you are endorsing a product, you are endorsing a particular brand, so this endorsement. F is false certificate. G is gifts from pharmaceutical companies or guaranteeing cure to his or her patient. You can't guarantee cure, you can say that you will be getting cure, but you can't guarantee it, right? And gifts from companies, you can't accept it. It is under professional misconduct also. Entire list is known as warning notice. Warning notice. Okay, don't confuse from warning and warning notice. Okay, warning is basically this. Look at this. So subcommittee, disciplinary action, subcommittee is performed. The subcommittee can acquit a doctor, warn a doctor, remove a doctor, name the doctor. So warning to a doctor is basically when he does anything negligent. Okay, warning notice is all of this. This is a list, and this list is given to all registered medical practitioners at the time of registration. Okay, they provide you this list that this will conduct professional misconduct, and you don't do that. So warning notice is received by all, and this warning is received by only one who has done something negligent. Professional secrecy. What is professional secrecy? Patient information is kept confidential. It is an implied contract between doctor and patient. Disclosure can be done only on patient's consent without warrant. If you are disclosing anything of the patient, if you are disclosing anything of the patient without consent, then it is punishable. This is breach of professional secrecy. But professional secrecy, some exceptions are there, like privileged communication. Exception to professional secrecy: privileged communication, information without consent of patient. You don't require the consent of patient, and you are disclosing information. Why you are disclosing? You can have four possibilities why you are disclosing an information without the consent of the patient. For community benefit, for patient's benefit, for self benefit, for court's benefit. Okay, community benefit. Let's say it is a notifiable condition like TB, cholera, COVID, in which you have to notify the number of cases. So you have to tell that the person has cholera. Okay, even if the person doesn't consent, you have to notify them. So notifiable disease for the benefit of the community you are doing. So that is a privileged communication. Venereal diseases, you are notifying that the person is having a venereal disease so that the STDs won't spread to another person. In case of crime, you have to inform the police, obviously. Okay, if it is not done, then it is punishable. Under 33 BNSS, it is mandatory to inform the police in case of a crime. In case of color blindness, for the benefit of others in the road. Okay, if a person is applying for a driving job, then you have to certify the color blindness status. If the person is telling you that he is not giving you consent to certify, but you have to do, because this is under privileged communication and it is an exception of professional secrecy. In infectious diseases, you have to inform the public health authority like CDMO and ADMO. For patient's benefit, if a patient has a suicidal tendency, then guardian must be informed. Okay, if you have consent, if you don't have consent, doesn't matter, you have to inform the guardian. In interest of self, if the patient has put in charge on the doctor, okay, so doctor, to save himself from the negligence charges, he can exercise the privileged communication clause, right? In court of law, in court ordered examination, in negligence cases, in basically all law related matters. Okay, in courts, you have to tell without any fear or without any consent of the patient. Okay, now Red Cross emblem is not to be used by medical practitioners. It is used by Red Cross movement or army medical services. If you misuse this emblem, then you can get a penalty of 500 or forfeiture of the goods and vehicles over which this emblem is being used, right? Then 5th century BC, Hippocratic oath came. This is a one-liner, so I included it in it. Some declarations are there. Okay, Tokyo torture. Okay, Tokyo declaration is about torture. Helsinki declaration about human experiment. Helsinki, HE, human experiment. Geneva is about medical ethics. You must have heard about medical ethics in Geneva, so no tricks. Oslo, therapeutic abortion. Okay, two O's here. Therapeutic abortion, Oslo. Sydney, organ transplantation. Venice, terminal illness. Lisbon, patient rights. Malta, in hunger strikes. Washington, biological weapons. Okay, Washington weapon. So this Tokyo, Helsinki, Geneva, Oslo and Washington are important. Okay. Then comes medical negligence. What is medical negligence? Professional negligence or professional malpractice. Okay, this medical negligence is known as professional negligence or medical malpractice. So it is defined as the omission of the right things, which the things which have to be done, you have omitted those things. Commission of the wrong things, the things which have it should not be done, you are committing it. Okay, so omission of right things or commission of wrong things which lead to the damage to the patient is called as professional malpractice or professional negligence or medical negligence, right? This is the thing. Absence of reasonable skill or care or willful negligence of doctor in treating the patient. Absence of reasonable skill or care. Reasonable, it's not expected from a MBBS graduate, right, to exercise something like a cardiac rehabilitation surgery or a open heart surgery like that. This is not reasonable. Okay, cardiac surgeon, a CTVS surgeon can do it. It is reasonable, but MBBS doctor has to provide some discipline, right? Discipline, okay, to a person with suspected cardiac abnormalities, right? So absence of reasonable skill or care is required, plus willful negligence of the doctor during treating the patient, which leads to the damage to the patient, constitutes the professional negligence. What is Bolam's test? Bolam's test is important thing. A doctor is not liable only when he practice standard guidelines or standard accepted practice. Okay, so if something is written in the standard guidelines of WHO or let's say American Heart Association or let's say FIGO guidelines, okay, anything, if a doctor is following that guidelines by some standard guidelines or standard accepted practical things, okay, so the person will not be liable for any damage to the patient. Okay, this is Bolam's test. And how will you certify? Expert witness will be sought over to determine if it were the standard guideline or accepted practice. Okay, what are the essential ingredients to prove a charge of negligence? What are the essential ingredients to prove a charge of negligence? This is a very important question, and for that we'll do, remember, 4 Ds. First D is the duty of care. A doctor may accept or may not accept, but if the doctor have accepted the patient, the doctor has to treat. Okay, so duty of care. If a doctor has admitted the patient in his hospital, now his responsibility is to treat the patient. He can't refuse that, it is not my case, right? But if you have not accepted it, then it's not your responsibility. Duty. Then dereliction of duty is basically neglect or breach of duty. Okay, neglect or breach of duty due to acceptance without adequate skills, due to choosing wrong treatment, administration of wrong medicines or wrong procedures. Okay, so wrong skills, wrong treatment, wrong medicine and wrong procedure due to which you are neglecting your duty is called dereliction of duty. Dereliction of duty is that duty is there, dereliction is there, then direct causation. So direct causation, negligent act is the direct proximate principle to the damage. Okay, so if any medicine is directly leading to damage, medicine prescribed by the doctor is directly leading to damage, this is dereliction. If the patient has consulted another doctor, another medicine is taking, and then you have prescribed another medicine, so you can't directly tell that your medicine has caused or this your medicine has caused the damage. It can be another doctor. So negligent act is the direct cause of damage. Okay, remote damage, doctor is not liable. Then damage is any monetary loss, pain or suffering, worsening, disability or death. Okay, it can be anything. It can be monetary loss, it can be inconvenience, it can be pain, it can be disability, it can be death. Okay, anything. So this 4 things are there. And 5th element, according to some books, damage must be reasonably foreseeable. We are not considering it. We have particularly 4 important ones: duty, dereliction, direct causation and damage. Okay, now we will move to the types of negligence. So civil negligence and criminal negligence. Civil negligence is simple lack of skill leading to the damage, right? It's not gross, it is very minor, like wrong dose, wrong prescription, right? So parties is patient and the doctor. Court is civil court. Even if a patient is treated free, he can file the case, and burden of proof lies upon the plaintiff, that is the patient. Patient has the burden of proof. Okay, so not gross error, just simple lack of skill or care. Criminal negligence, if you remember the words: gross, willful, wanton, culpable, utter carelessness or illegal act. It is utter carelessness, it's a gross negligence, like a wrong surgery, okay, or you operated on a wrong patient. A patient is admitted for appendicitis. You did something like a hernia repair or something like that, a wrong side surgery. He had left leg amputation, you amputated the right leg. Wrong blood transfusion, you did a B positive patient with a negative blood, right? Foreign body inside, right? You left a seizure inside the patient. Wrong medicine in eye, which lead to loss of vision. Okay, party is again prosecutor versus the doctor. Prosecution versus doctor. Court is criminal court now. Okay, small thing, civil or consumer court, but criminal negligence is basically tried in criminal court, and burden of proof lies upon the prosecution. Judgment. What is the judgment in case of civil negligence? Monetary compensation, known as damages. Okay, so the doctor has to pay some damages, monetary compensation. But here in criminal negligence, there is fine or jail imprisonment under 106 BNS. 125 BNS is any rash or negligent act endangering patient life. Okay, so 125 BNS, any act which is causing damage to the patient's life. 125A is the doctor is causing hurt, any activity of the doctor causing hurt. 125B, any rash or negligent act causing grievous hurt, right? 106 BNS, any act which is leading to death of the patient. Okay, this anything which is leading to the death of the patient. Sorry. 271, fatal infection. 272, any malignant intention of the doctor which causes the spread of the infection, right? So if the doctor is having some malignant intention, okay, due to his there is a spread of fatal infection, it is charged under 272 BNS. 271 BNS is any negligent act causing spread of fatal infection. Contributory negligence applies for civil cases. Doctor has some negligent act and patient has contributed in it. Okay, doctor is doing some negligent act, but patient is also responsible. Like incorrect history by patient, improper follow-up, improper medication. Improper history, improper follow-up, improper medication. Okay, so the burden of proof now lies upon the doctor, right? So the doctor had advised paracetamol, the patient has taken let's say azithromycin. Okay, the patient has given wrong history is wrong. The patient hasn't come for follow-up. The doctor had asked to come for follow-up after 15 days. The patient is coming after 1 year. This is also contributory negligence. Then doctrine of comparative negligence. In case of contributory negligence, in case there is a contributory negligence, we have a doctrine of comparative negligence. Means who is more negligent, to determine whose contribution is negligence is more or less, right? Is the patient more negligent than the doctor, or the doctor is more negligent than the patient? Used by the judge. Okay, then last clear chance doctrine and avoidable consequence rule. Last clear chance doctrine means when two parties are wrong, one had the last clear chance to avoid the damage is liable, right? Both doctor and the patient parties are wrong, but if the patient had done something which had prevented the damage, then doctor can apply this doctrine to get rid of the charges of the medical negligence. Okay. Now the doctor is there and patient is there. The patient is of snake bite. The doctor hasn't put any TT, right? He is negligent, of course, but patient basically uh, tied a tourniquet after seeing the doctor, tied a tourniquet thinking that the snake venom won't travel. Okay, due to tourniquet, there is heavy lymphadenopathy and secondary infections. So here both are negligent, but the damage is because of that patient chance. The patient had the last clear chance to avoid the damage, but the patient preferred to tie the tourniquet. So here the patient is more liable. So doctor can file in, can get, you can say, freedom from the negligent cases, not complete freedom, but to some extent, because the patient had the last chance to avoid the damage. Then avoidable consequence rule. Doctor is negligent, but duty of patient is to avoid further damage. Okay, here doctor is also negligent, but duty of patient is to avoid further damage. Here patient is liable. There is a negligent act of doctor, but patient would have he had asked the patient to do something which the patient hasn't done. So patient is liable here. Patient is negligent here. Okay, he can't file the case against the doctor now. So avoidable consequence rule and last clear chance doctrine. These are the things. Patient has to prove unreasonable act, which is not res ipsa loquitur. Which is res ipsa loquitur? Anything which is speaking for itself. Anything, any negligent act where there is nothing extra needed to prove the negligence. Like a person has left leg amputation. Okay, left leg amputation planned, but the doctor amputated right leg. So this is seen, this is visible to public, this is visible to everywhere, to anywhere, that the right leg has been amputated. So there is nothing extra to be proved to prove the negligence. The damage is proved by the act itself, like wrong side surgery, no TT injection, foreign body inside abdomen, res ipsa loquitur. Okay, no expert witness is not required, burden of proof lies upon the doctor. Doctrine of common knowledge, no need of expert witness. Like everyone knows that IV fluid have to be given in case of dehydration. There is nothing needed of expert witness to prove the charge of negligence. If IV fluid haven't been administered to the patient of dehydration, then it is a doctrine of common knowledge, right? Now, doctrine of calculated risk, because every procedure has a certain risk. So doctor is not liable if he has conveyed the risk to the patient. The doctor has told the patient that we are doing cesarean section, you have 0.1% risk of dying. So if the patient died, the doctor is not liable because doctor has already communicated the risk, provided that the doctor is doing correct procedures. Now, novus actus interveniens, new act intervening, means there is a negligent act, but after some time there is a new unrelated act which leads to damage. So basically the chain of sequence is broken. Here you can sue the previous doctor. Okay, let's say a person developed RTA, that is road traffic accident. He went into shock, right? And here another doctor is now treating. Okay, he went into shock, but another doctor is now treating who did mismatched blood transfusion. Okay, the person's RTA was treated. His wound were debrided. He was provided adequate first aid, etc. by Doctor 1. This is the Doctor 1. Okay, he has done everything. But this is Doctor 2. Okay, this Doctor 2 is using mismatched blood to transfuse the patient. Mismatched blood transfusion. And this mismatched blood transfusion is related to death. So you can sue the Doctor 2. You can sue the Doctor 2 in court. Doctor 2 in court. You can't sue the Doctor 1. He has done his duty of first aid. Okay. So this phenomenon is called as novus actus interveniens, that is new unrelated act intervening. Now, vicarious liability. Superior is responsible for the negligent act of the third party. Okay, comes under respondent superior, let the master answer. So if a doctor is being charged of negligence, then the hospital authorities is also responsible. This is vicarious liability. Your superior is responsible for your actions. Applicable for civil cases only, right? Product liability, faulty medical device, manufacturer is liable. Here doctor is again not liable. A person sues you that you have given me expired medicines. Okay, a current case I am telling. In this where the doctor was resigned, or doctor faced very backlash for giving expired cough syrups, right? But this here in cases manufacturer is liable, not the doctor. Okay, to faulty medical device or drug, manufacturer is liable, not the doctor. This is called product liability. Borrowed service doctrine. If a servant is borrowed for an act, the new temporary employer is liable for the negligent act. Let's say here you have a hospital. Okay, here you have a hospital, and the hospital has borrowed a doctor. Okay, so if this doctor does any negligence, if the doctor left in negligence, then this temporary hospital in which he is employed, this will be responsible. The original hospital of the doctor won't be responsible. So borrowed servant doctrine. Captain of the ship doctor means variant of borrowed servant, means if one of the staff does a negligent act, main doctor is responsible. If the intern does a negligent act, then the HOD is responsible. Defenses. Okay, what are the defenses you can use? Denial of duty or dereliction. If you haven't admitted the patient, how you are responsible? Okay, so for any you can say charges of criminal negligence, there must be duty first, right? Duty first. So if you haven't admitted the patient in your hospital, then how you are charged of negligence? If you have denied the treatment of the patient, then you are not responsible, right? So you can apply this denial of duty or dereliction. Double jeopardy. Double jeopardy is res judicata. A individual cannot be tried twice for the same offense of the same facts. Okay, if a doctor cannot be tried twice for the same offense and same facts, if any other facts, the person is additional facts are there, then he or she can be tried, right? So if you are tried once, you cannot be tried again for that same offense. So double jeopardy, res judicata. Accidental act or unincidental act, okay, it leads to damage. This is called therapeutic misadventure. Here doctor is not liable because it is an accidental act. Doctor has no control over that act. It is an accidental act, it is an unincidental act which is leading to damage. Mal-occurrence, proper attention to patient but still no improvement. Doctor is not responsible because patient's health is influenced by genetics, influenced by environment, influenced by its immunocompromised situation, influenced by many factors. It's multifactorial. So even if doctor is treating the patient and patient is not improving, doctor is providing best treatment, but patient is not improving, then doctor is not responsible for that. It's the patient body which is like reacting like that. So it is mal-occurrence. Voluntary non-fit injuria. If you to a willing person, no wrong done. Okay, so if the doctor is not liable in case there is a on-table death for CABG. So voluntary non-fit injuria means doctor has prepared a report that this is the procedure, this CABG is the procedure, and you can die. You can die. These are some chances of death, and the person has signed in it. Okay, voluntary non-fit injuria. So he is a willing person to undergo the surgery. So if the person now dies, then doctor is not liable at all. You can show the paper in which you have taken consent and made the risks identifiable to the patient. Res indicata. Res indicata is limitation period, that is of 2 years. Limitation period means time period within which the victim has to file the case in case of civil cases. In case of civil cases or civil negligence, the victim can file the case within 2 years. If there is more than 2 years, the doctor can file res indicata. The doctor can use the defense res indicata and get over with. Res indicata limitation period has crossed, so I am now not negligent. And you can act novus actus interveniens. You can have contributory negligence, which you discussed, doctrine of calculated risk, and products liability. Doctor prescribed medicine, defective drug, so manufacturer is liable, not the doctor. Okay, and burden of proof is upon the manufacturer only, right? Okay, so this is medical negligence. This defenses you have to remember. Then we come to professional misconduct. What is professional misconduct? Conduct which is considered reasonable, disgraceful, dishonorable by professional brethren of good repute and competence, right? It is a conduct which is considered reasonably disgraceful and dishonorable by a professional brethren of good repute and competence. Okay. And then what are the duties of medical practice in the treatment of the patient? To establish the doctor-patient relationship. Doctor-patient relationship is not established in case of emergency. In case of emergency, there is no talking between the doctor and the patient. So a relationship is not established. Examining an employee before appointment or life insurance purpose or medical legal case, there is no doctor-patient relationship. This is permissible. Okay, these exceptions are permissible. Duty to continue treatment can be discontinued if the doctor has a duty to continue the treatment, but doctor can discontinue the treatment. A doctor can discontinue the treatment in case patient is malingering. Malingering means feigning the illness, that is he is making up an act. Okay, he's making up an act and saying false things about his illness. Okay, using random medicines. You have prescribed him paracetamol and he is taking some jadi booty and etc. Ayurvedic medicines. Consulting another doctor without informing. Many patients do it. Okay, the patient is consulting another doctor besides you, then you can refuse treatment to that patient. Patient is not paying fee in private setups. Okay, in government setups you are bound, but if a patient is not paying your fee, your reasonable fee, that is 200 or 300 rupees or something like that, right? Patient is not paying you this much, then you can discontinue his treatment, no problem. And doctor himself falls sick. Doctor has to exercise a reasonable degree of skill, care and knowledge. Doctor cannot experiment, only established treatment plan he can give. Extra care and precautions must be taken to habit forming drugs, and proper instructions, basically legible prescription. The prescription must be legible, prescription must be in block letters. Okay, it must contain the advices, it must contain how much to be taken, okay, once daily, after meals, before meals, everything must be mentioned. Okay, EMRB I told you. Medical Advisory Council is there, another thing. MAC, Medical Advisory Council, are the members: chairman of University Grant Commission, chairman of NAAC, and members nominated by states. State Medical Council, I told you, autonomous body. Medical register, disciplinary action, warning notice. Warning notice is a cautionary notice given by SMC after inquiry, doctor guilty of infamous misconduct. Warning and warning notice, what is these are the things which is different. Warning versus warning notice. Warning is given by SMC in case of infamous conduct or professional misconduct, but warning notice is a circulated by SMC periodically describing professional misconduct. This A, B, C, D, E, F, G, H, right? This is a warning notice. So complaint, these are the things. Advantages of registration. What are the advantages of your medical registration? You have a right to choose patient. You have a right to add title like doctor before your name. You have a right to claim reasonable fee. Okay, you have a right to prescribe medicine, right for appointment, right to conduct autopsy, give evidence and issue medical certificates, and remove eyes for organ transplantation. These are the benefits of your medical registration. Okay, and medical registration is done by SMC, that is State Medical Council. So right to choose patient, right to add title, right to claim reasonable fee, prescribe medicines, remove eyes, appointments, autopsies, etc. Okay, in what cases you have to consult with a senior colleague or specialist if the patient requests. If the patient is sitting beside you and a patient is telling himself that please do ask some colleague of your surgery department and tell me. So you have to be under the patient's request, right? If you're not sure about diagnosis, you can call if a colleague and you can consult him. If during treatment of criminal abortion, in homicidal poisonings, you can consult with a senior colleague. Okay. Now, duties under Geneva Convention. We have 4 conventions. Geneva Convention, 4 conventions. First, second, third, and fourth. 4 conventions are there. First, wounded and sick personnel of army. Second, shipwrecked. Third, prisoner of wars. And fourth, civilians of enemy country. Okay. Before treating patients, you have to classify the duties under 4 Geneva Conventions. And this is the thing. 4 conventions. First is the wounded and sick of army. Wounded and sick of army. Okay, first 1A you can remember like this. Okay, second ship. Okay, SECOND is second, and SHIP is ship. Okay, so shipwrecked you can remember like this. Okay, third is basically war. WAR, war 1, 2 and 3. Okay, war. And fourth is basically enemy country. Okay, Red Cross, Red Crescent, Red Crystal only by personnel during wars, I told you. And if this Red Cross is used then by a doctor, then 500 can be fine, or it may lead to forfeiture of goods on vehicles. Okay, this we talked. Defenses I told you. Contributory negligence I told you. In case of LAMA also, LAMA is leaves against medical advice. If a person has left, he was admitted and left for another doctor, then also you can charge him for contributory negligence. You can just use a defense called contributory negligence in this case also, right? In terms of third party, res judicata we talked. Res judicata, if the negligence charges cleared by lower court, then patient is not allowed to plead the higher court, right? So he can be tried only for the same, only for one time for the same act, for the same evidences, right? Okay. Consumer Protection Act to bring transparency in business, quality goods at regulated price, after sale service. Okay, public, private and corporate sectors. Service rendered by doctors also are brought under Consumer Protection Act in 1995. This is a controversial decision because this is not a you can say many finances or economical related service provided by doctors. It is basically care. So, and patient is consumer, doctor is shopkeeper. This relationship many oppose it, but it is under CPA, that is Consumer Protection Act in 1995. And consumer court has 3 forums: District Consumer Redressal Forum, State Consumer Redressal Forum and National Consumer Redressal Forum in New Delhi, right? So District Consumer Redressal Forum, there is a district judge, 2 other citizens, and up to 5 lakhs compensation can be granted from District Consumer Redressal Forum. State Consumer Redressal Forum, a High Court judge is there plus 2 eminent citizens, 5 to 20 lakhs, and National Consumer Redressal Forum New Delhi, 20 lakhs compensation can be, more than 20 lakhs, right? And what is the process? Complaint lodges the complaint in consumer court issues a notice. Okay, within 30 days, if there is a reply, then hearing verdict will occur, and more than 30 days no reply, then one more chance is given for hear, right? If lab tests are not done, then it is completed within 90 days. Within 90 days your plea, your charges are done away with. Okay, so it is a very fast procedure. It is a very fast procedure basically, because less than 30 days you get a reply, and within 90 days your trial, hear verdict, etc. Your damages you will get. Okay, if a doctor is charged of negligence, right? If there is laboratory test, then 150 days will be the max, right? Medical indemnity insurance. Medical practitioners during professional work has a risk of facing medical negligence. So insurance is there against such charges. Okay, if the doctor has to pay damages, right? Damages if he is charged of any civil negligence or something like that. So doctors usually do medical indemnity insurance to cover themselves against such charges. Malingering, deliberate attempt or conscious planned feigning or pretending a disease on the part of the patient. Patient is pretending a disease. Soldiers, prisoners, businessmen, political leaders, many things are there. Signs and symptoms do not match any known disease, kept under observation, and you have to watch him without knowledge. Okay, without his knowledge you have to watch him, so that you know that the patient is feigning illness. Only organ can be donated during life is kidney. This is the one-liner. Nowadays liver can be donated too. Okay. PCPNDT Act. PCPNDT Act is basically Preconception and Prenatal Diagnostic Technique Act 1994. Okay, so PCPNDT Act is basically Preconceptional Prenatal Diagnostic Technique Act 1994. Prohibition of sex selection before and after conception. Purpose was to prevent female feticide. Okay, a person cannot choose if he wants a boy or a girl, and because people were killing the girl child, female feticide, a person cannot prenatally means within before delivery. Before delivery, a person cannot determine if his child will be boy or girl. Okay. Genetic counseling center, genetic lab and clinics should be registered under PCPNDT Act, and if this is done, action is taken by state medical council and also legal action is taken. Okay. And now last thing is that medical records. What are the medical records? Confidential records. Hospital has right to use the medical records for statistical purpose or quality care determination purpose. Basically for preventive and social health perspective, these medical records can be used. Medical records have to be kept confidential, and hospital has the right to use the records for statistical purpose and quality improvement purpose, right? And next up can get the record in case of patient's death. If a patient is dead, the patient's son can get the medical records of his father or mother. Physicians should maintain the record for 3 years from commencement of the treatment. Okay, so every physician must maintain a medical record for 3 years. 3 years. And medical legal case, you have to maintain it for 30 years. Okay, medical legal case or any suspect formation of medical legal case, then you have to preserve it for 30 years. Now comes consent. What is consent? Consent is basically something, agreement, permission or compliance. Consent means agreement, a permission or a compliance. When 2 or more person consent, they agree upon the same thing in same sense. Okay. So Indian Contract Act, section 13 of Indian Contract Act basically is giving you can say provisions under which a consent can be made. Examination of treatment without consent is resulting to assault, which is punishable under 131 BNS. So 131 BNS is about assault, and this assault is basically a result of treatment without consent. Other types of consent: implied consent, consent by gesture. If person is coming to you, coming to your clinic and is sitting there, so he has implied a consent that you can check his temperature, you can check his blood pressure. Okay, you can do your routine examination because it's implied consent. Expressed consent, verbal or written. A person is a victim, is a rape alleged person. Okay, he has come for checkup. Okay, victim of rape. So you have to take consent. You have to take consent from her beforehand, before examination. This is the expressed consent, maybe verbal or written, but in this cases it is basically written. Okay, so written consent is the best consent. Written informed consent is the best consent. Surrogate consent, proxy consent given by another person. If a child, okay, a child cannot give a consent, a mentally ill person cannot give a consent, an intoxicated person cannot give a consent. If in that person's place another person gives consent for any medical procedure or examination, then this is a surrogate or proxy consent. Open consent, generic consent or blanket consent is an invalid concept in India. One consent for all investigation and procedure. You took one consent from the person, you did his CBC, you did his ultrasound, you did his something, you did his surgery, if you did a procedure. Okay, you took one consent and you did everything. So this is a blanket consent or open consent or generic consent. Okay, open, generic or blanket. So one consent for all investigation procedures and etc. This is invalid in India. Authorized consent is mandated by court or law. Okay. Other doctrines: doctrine of full disclosure, doctrine of partial disclosure, doctrine of informed refusal, doctrine of extended consent, doctrine of therapeutic waiver, doctrine of emergency, and doctrine of loco parentis. Okay. So doctrines related to consent: doctrine of full disclosure. You have to give complete information to the patient. If you give inadequate information to the patient, then there is no consent associated with it. Doctrine of partial disclosure: therapeutic privilege, right? Let's say exception to full disclosure, you are not disclosing complete things about the patient. You are not disclosing that the patient is ill or something for the patient's benefit. Okay, you are not doing for your own benefit, for patient's benefit. Like in psychiatric illness, you can't disclose a psychiatric patient, you can't disclose a patient of severe depression that the patient is in depression. Okay, doctor have informed refusal, patient has right to refuse the treatment. Okay, and if the patient has refused the treatment, do document it and to take the patient sign. Doctrine of extended consent for specific procedure. If new issue arises, then doctor can extend the consent for additional condition. Let's say you are doing a surgery for appendectomy. Okay, appendectomy, and some vital organs get injured, then you have to repair that organ also. So the doctors extended the consent and valid only for life-saving operations. Okay, because patient can bleed and die, so doctors extended the consent for patient's benefit. So main thing is that the patient has to be benefited. Okay, patient has to be benefited and doctor has to be saved. So this is the essence. If this essence is clear, you can make your own rules, right? Doctrine of therapeutic waiver. If the patient is waiving his right of consent and authorizing someone to give consent for him. Doctrine of therapeutic waiver means that the patient has authorized some individual in which he is interested, or in which his kin or his family member to give consent for himself. Doctrine of emergency 30 BNS. Consent is non-mandatory. You cannot take a consent for doing a tracheostomy to a person of who cannot breathe. You cannot take consent there. You have to do tracheostomy. Okay, no consent is required. Doctrine of loco parentis. If a child is less than 12 years, then person in charge will give the consent. If it is a less than 12 years, then person in charge will give a consent. The parent will give a consent. The guardian will give a consent. The consent is valid only when it is free and voluntary. There is no force or coercion. There is physically competent, a sound mind, sane person, not insane. Intoxication. If a person is intoxicated, look at this. If a person is intoxicated, let's say, so you can apply the doctrine of emergency if it is life-threatening condition. You can apply the doctrine of extended consent. Okay, or you can apply anything, but you have to you can take a surrogate consent. Because the person is intoxicated, right? Okay. No undue influence must be there, no fraud must be there. Medical examination. So general physical examination, a person can less than 12 years, consent can be given by guardian. But if there is a major procedures, okay, minimum age of consent is 18 years. A 12-year person cannot give consent for major procedures, right? So 18 years. Medical legal examination in case of rape. Accused, consent is not mandatory. Over 52 BNSS, okay, consent is not mandatory. The victim, consent is mandatory. 184 BNSS. So victim can refuse the examination, and if he is refusing, then you have to take a informed refusal. Autopsy, most common autopsy, no consent needed. Pathological autopsy, consent is mandatory. MTP minimum age is 18 years. Less than 18 years, mentally ill, legal guardian has to consent. Consent of female is mandatory. Husband's consent is not needed. No need of husband consent. Act not intended to cause death, cause and content not offense under 26 BNS. Act done in good faith for the benefit of child or benefit of the thing is not an offense, is 27 BNS. Okay, so if a doctor is not planning to harm someone, okay, but this was done in good faith for the person's benefit, then it is not an offense under 26 BNS, right? If an act is done in good faith for the benefit of the child, in case of child, or by the consent of guardian, it is not an offense, it is under 27 BNS. Okay, act done in good faith for the benefit of a person without consent. If consent is not taken but act is done in good faith, example in case of emergencies, then 30 BNS. Examination of under trial prisoner, consent is mandatory. Examination of convict, consent can be obtained from jail authority. If everything is not disclosed to the patient cannot take a rational decision. This is called paternalism. If everything is not disclosed to the patient can take a irrational decision. irrational decision, and this is called as paternalism. Blanket consent, I told you, open consent or generic consent. Last section of this chapter is euthanasia, that is mercy killing. Form of homicide to terminate his or her suffering or incurable pain. Let's say a person is suffering from incurable pain or sufferings, then the person can opt for homicide. Okay, person can authorize someone to kill him. Okay, from homicide also, to terminate the suffering. Let's say a person is suffering from cancer and is having chronic pain, chronic high grade pain, severe pain, body is being ate up by the cancer cells, right? So person can end his life voluntarily, right? And this voluntary form of homicide is called as euthanasia. Active euthanasia and passive euthanasia are two things. Passive euthanasia, person dies of natural outcomes, he is abandoned, so act of omission is being there. Passive euthanasia means you are not doing anything, you are not doing anything, but you are switching off support to the patient. Okay, like you are not giving food and water, you are removing the life support, you are switching off the ICU machines, you are switching off the heart and lung machine, you are not giving CPR, you are stopping medical support. This is passive euthanasia. The person is abandoned. Okay, this is passive euthanasia, and main thing is that the person is willfully abandoned. Okay, it's not like that the person is not given food and water and the person is asking for food and water and we are not giving. It's crime, right? It's not euthanasia. Euthanasia is the person has himself asked not to give him food or water, the person has himself asked to switch off the ICU machines, etc. Active euthanasia in here is causing death by direct action in response to patient's request. Act of commission, you are doing something for euthanasia, like you are loading sedatives or loading high dose of alprazolam, lorazepam, etc. high doses, right? Sedatives, overdose. Injecting air into veins, air embolism, person can die of air embolism. These are painless deaths. Sedative, air, okay, these are not causing pain, the person is peacefully dying. Now physician assisted suicide, they are asking the doctor for suicide, the physician will prescribe a high dose of sedative, carbon monoxide, okay, all of this to assist the suicide or assist in euthanasia. In what circumstances the person will have a euthanasia? Physically and mentally handicapped, cancer patients, AIDS patient, AIDS last stages, cancer 4th stage cancer, 3rd stage cancer, senile dementia, unforeseen mishaps, brain damage. The person is in coma for years, the person is suffering but is not able to tell. Okay, so to achieve voluntary euthanasia, the person has to get a advanced directive, a DNR order, a self-determination act. Okay, that's it, voluntary euthanasia. Voluntary euthanasia means the person himself wants euthanasia. Okay, so advanced direction is needed. A DNR order means do not resuscitate, means do not give CPR, don't give CPR order. Okay, the person has written don't give CPR, don't give me CPR order, and self-determination act. For involuntary euthanasia, person is involuntary euthanasia, the person cannot speak, so relatives have to be the voice of the patient. The guardian ad litem, is the guardian will be responsible for the euthanasia. Okay, ethical issues. What are the ethical issues in euthanasia? Euthanasia is illegal in many places also, right? So ethical issues, basically you are hampering the right of life, you are hampering the right of dignity, you are hampering the right of self-determination, and Hippocratic oath is grossly compromised. Code of medical ethics says that everything you do must be in the benefit of the patient. Okay, you must have heard about the we talked today about ABCDE principle, do no harm, but here you are killing the patient voluntarily. Okay, it may be voluntary, it may be involuntary, but you are killing, right? So Hippocratic oath, code of medical ethics, it may have compromised right to life, right to dignity, right to self-determination, these are also hampered, and this finishes the euthanasia topic, right? So this is a debatable topic, but sometimes you get a short note, so I taught you also. Okay, so that's all in today's session, and we'll meet again with another unit. So our first unit, that is the medical ethics, medical negligence, law, ethics, and all are done. Okay, thank you and have a nice day.